In cross-border estate planning, the way an asset is owned often matters more than the will itself. Joint ownership and separate ownership produce fundamentally different inheritance consequences. In multinational families connected to Vietnam, this distinction becomes strategic. Separate ownership means the asset belongs legally to one individual. Upon death, that individual's ownership interest forms part of the estate. Distribution then follows the will or statutory inheritance rules. Joint ownership means two or more individuals hold rights in the same asset. However, the legal effect of joint ownership varies by jurisdiction. Not all systems recognize survivorship in the same way. Under Vietnamese law, co-ownership is generally classified as ownership by defined shares or common ownership without defined shares. Vietnamese law does not recognize the common law concept of automatic survivorship. When a co-owner dies, their ownership portion becomes part of the estate and is distributed under inheritance rules, unless marital property division applies first. Many expats assume that holding property jointly in Vietnam ensures automatic transfer to the surviving spouse. This assumption may be incorrect. Vietnamese inheritance law may still require formal succession procedures. For property located in Vietnam, assets acquired during marriage are generally presumed to be common marital property unless a valid marital agreement provides otherwise. Upon death, the surviving spouse retains their share of common property. Only the deceased spouse's portion becomes subject to inheritance distribution. Assets owned before marriage or acquired through inheritance or gift may be classified as separate property. Only the deceased separate property becomes part of the estate. Classification determines exposure. For real estate located in Vietnam, Vietnamese law governs succession regardless of nationality. Joint ownership does not eliminate inheritance procedure. Registration updates remain required. In some foreign jurisdictions, joint tenancy includes automatic survivorship. Assets may transfer directly to the surviving co-owner without probate. However, this effect depends entirely on the governing law of the asset location. A family may hold property in Vietnam under co-ownership without survivorship, while holding foreign assets under joint tenancy with survivorship. Different rules apply simultaneously. Estate planning must account for this divergence. Joint ownership with survivorship abroad may override testamentary intentions. If one spouse dies, the asset may pass entirely to the survivor, bypassing children. This may conflict with broader estate objectives. In Vietnam, compulsory heir protections apply to the deceased share of jointly held property. Joint ownership does not remove that portion from the estate. Mandatory inheritance provisions remain applicable to the decedent's interest. Shares in Vietnamese companies may be held jointly or separately. Upon death of one shareholder, inheritance procedures apply to that share. Corporate governance implications follow. Transfer of ownership after death may trigger tax or administrative fees depending on classification and relationship. Joint ownership does not automatically eliminate reporting obligations. Procedural compliance remains required. Joint ownership may simplify asset management during lifetime. In jurisdictions recognizing survivorship, it may reduce inheritance administration procedures. However, its legal impact must be analyzed asset by asset and jurisdiction by jurisdiction. Separate ownership allows clearer testamentary control. Distribution can be tailored through a will in compliance with local inheritance law. Flexibility may outweigh convenience. Ownership structure should reflect long-term succession goals. If the objective is spousal protection, marital property planning may suffice. If the objective includes children from prior relationships, careful allocation is essential. In Vietnam, land use rights certificates and corporate registries determine legal ownership. Accurate documentation prevents dispute. Ambiguity invites litigation. Do not assume that joint ownership automatically avoids probate or inheritance procedures in Vietnam. Analyze each asset under its governing law. Structure ownership deliberately rather than by convenience. In cross-border estate planning, joint ownership and separate ownership produce different legal outcomes. Vietnamese law does not automatically apply survivorship to co-owned assets. Estate planning begins with ownership structure. Without deliberate alignment, the form of ownership may determine succession more than the will itself. In cross-border estate planning, ownership structure is not a technical detail, it is a succession decision. Vietnamese law does not automatically apply survivorship to co-owned assets, and foreign survivorship rules may override testamentary intent. If your assets are held jointly across jurisdictions, a structured legal review is essential. Contact LTS Law at lts.com.vn to align ownership structure with your long-term estate objectives. In multinational estates, how you own an asset may matter more than how you write your will.